Who's the attorney? All right, come forward, sir. So where are we on discovery?
Your Honor, this is a case that has, it's an older case, but it's finally got indicted. The government's made an offer of discovery. I'm having some difficulty downloading it because I moved to Corpus.
Mhm.
And I think from what we can tell from IT is because the IP address moved and the VPN that it doesn't allow it to come in. So we're still working with IT on it.
Mm-hmm.
In any event, the prosecutor is nice enough to say if I bring a hard drive or a disk, that will be the evidence on. I don't anticipate it's a law. It
shouldn't be too long, no.
Okay.
I can probably have it done in a day when he drops it off.
All right, Ms. Ferguson, I need a reset date. We'll recall this in 45 days for a plea deadline date. All right. What date? All right, so we'll be back on November 10th. Thank you for dressing appropriately for court. Just have a seat. And once you sign the reset form, you'll be excused. All right, thank you. All right, Jorge Morales. Come forward. Hi, you were supposed to have an attorney?
Yes, ma'am, but I need a little bit more time because I need more money.
No. And let me just tell you why.
Yes, ma'am.
We've been waiting for you to hire an attorney and for a long time now. And
the case, I barely got it last month of the case.
No, here's the thing.
Yes, ma'am.
We cannot have a case out there forever because of you're waiting to hire an attorney. So just have a seat.
Okay.
And you're going to be interviewed for an attorney because you've had over 45 days to get an attorney. So just have a seat, okay?
Yes, ma'am.
Thank you. Alexis Hernandez. So how did your jury trial go?
About as well as a murder trial in Karnes City was going to go, Judge.
Oh, and how far, I'm trying to learn the distance of all the counties. So how far is Karnes from here?
From downtown, it's about an hour. Mm-hmm. So you go to Wilson County, that's Floresville, it's about 35 minutes.
Mm-hmm.
And then Karnes City is another 25 minutes past that.
Yeah. Okay.
You just keep going down the same freeway or highway.
Okay.
Yeah.
So where are we on discovery?
I've been given discovery where he and I need to review it together.
Okay.
So
and was the state able to tender an offer?
The state has tendered an offer. Yes, Judge.
All right, Norma, I need a reset date, 45 days. That will be your plea deadline date.
Thank you, Judge.
All right, so we'll be back on November 10th. Thank you for dressing appropriately for court. Just have a seat. Once you sign the reset form, you're excused.
Okay, thank you, ma'am.
All right, you're welcome. You say Jesse Garza?
Yes.
Jesse Emmanuel Garza. All right, and I believe this may be criminal trial division.
It is, Judge. Yes. He conferred and we're rejecting the plea bargain offer.
All right.
We're asking for a trial date.
One, I need to make sure that y'all do a acknowledgement of discovery. And then how long do y'all expect this trial to last?
I think it's about 3 days.
All right, Norm, I need a jury trial date, 3 days. Good morning.
Good morning, Jim.
Yeah. Thank you for dressing. You're dressed very appropriate for court. Thank you so much. All right, November 10th.
Yes, Judge.
All right, so we'll be back here on November 10th. What I can tell you about jury trial dates, there's going to be more than one person set for jury trial. The reason why that happens is because sometimes there's a new offer that's tendered and maybe it's accepted. And if I didn't have more than one person scheduled for jury trial, then we lose that whole day. So I don't believe that you are number one, but you'll be on the list. So if other cases work out and we get to you, we'll get to you. All right. All right. Just have a seat. Once you sign the reset form, you're excused. And counsel, if you can make sure you sign the acknowledgement of discovery.
I will, Judge.
All right. Thank you.
Thank you, Judge. We'll have the same announcement on Mr. Pettis, so I'll make sure we have more release.
All right. Thank you.
Thank you, Judge. Have a good day.
All right. You too. Thank you. Emmanuel Pettis.
President custody.
All right. And state on that one as well.
Discovery.
All right. Thank you. All right. Mr. Emmanuel Pettis, if you'll come down, please. And on this one as well, are you asking for a jury trial?
Yes, Judge.
All right, Ms. Ferguson, do you want this state?
Yes, Judge.
he's going to be asking for a jury trial on this as well. Is it too much to have it on the same date as this other client?
No.
All right, Norma, are you able to put this on the November 10th as well? All right, so your jury trial date will be November 10th. Thank you for dressing appropriately for court. And the same thing that I told the other gentleman applies. You'll be in line for jury trial that day, okay?
Okay.
All right, thank you.
Thank
Okay.
Adrian Hernandez? All right. So where are we on discovery?
So here's what's going on. The MTR is actually the case that's set today. Then there are 4 additional cases newly indicted that they just brought the files down on.
Mhm.
I'm asking the court for a reset so that I can get through and see if we have all the discovery that we need on all 4 of the kind of heavy hitting cases, and then see if I can't work it out in some way with the prosecutors.
All right, could I see the motion to revoke, please? And is that the evading? Ah, thank you. That's okay, I have it.
It's mostly the new number ones, but there are a couple of drug violations, but mostly new number ones.
And these are criminal trial division?
Yes, they're all criminal probables.
Okay. Who is the prosecutor on Isaac Hernandez? All right, so with regards to the number ones that are in the motion to revoke, do you know if you have all the discovery, or is there maybe
Judge, I was
something
looking
outstanding?
at it. I think there may be a couple of things outstanding. They are indicted, but you know how that goes around
Yeah.
here. So I was looking at them today. I think there are.
Right out of the gate, you can see how procedural this courtroom is. Discovery issues over a VPN that might sound technical, but it actually matters. If the defense doesn't properly receive evidence, the clock can't really move forward. And here's the bigger question. Should tech hiccups buy more time in a criminal case, or is that just part of modern law practice?
Were things that were missing. So I was hoping to reach out to the arresting agency and then get with Ms. Christian to get her a global offer to proceed.
All right, so how much time are you all asking for?
I'd say 45 days if we could.
Okay, then this is what I'm going to do. Ms. Abrams, I'm going to set this for 45 days. And then if an agreement is not reached, I'll need to set the motion to revoke because it just can't be hanging out there forever.
Understood, Judge.
All right, so it's going to be recalled in 45 days, but that's not going to be a contested. All right, Ms. Ferguson, I need a 45-day reset. It'll be for discovery.
Yes.
All right, so we'll be back on November 10th. That's for your attorney to get the discovery on the allegations and the motion to revoke. And counsel, you're appointed on all of those cases?
I am, Judge.
All right. All right, we'll see you on November 10th.
Thank you.
Yes, ma'am.
You're welcome. Case Anthony Lopez. All right, so the last time we were here, there was a request for the EMS records. Do you have those?
We received those, Your Honor. We reviewed them and we made an offer by the state that is open until the next setting. We would like to set this for a plea deadline if the court is inclined to do so.
How old are you?
28.
All right, Ms. Ferguson, I need a 3-week reset for a plea deadline date, please. All right, it'll be October 16th. And state on Chase Anthony Lopez, if I can get an acknowledgement of discovery, please. All right, thank you for dressing appropriately for court. You're excused as soon as you sign the reset form. Just have a seat and your attorney will bring that to you. And please do not leave without signing the acknowledgement of discovery.
Yes, Your Honor.
All right,
Thank you.
thanks. Are you all ready to proceed on the motion to revoke on Mark Anthony Pettis? All right, the court is calling 2024 CR 2594 State versus Mark Anthony Pettis. Can I have parties announced?
Rick Payne for the state of Texas.
Michael Dwight Goins, the defendant, Your Honor.
And are you Mark Anthony Pettis?
Yes, ma'am. Yes,
Did
Your
you
Honor.
review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Mark Anthony Pettis who was placed on community supervision in 2024 CR 2594 for the offense of injury to the elderly bodily injury on May 28, 2024 for a term of 3 years? Is that you?
Yes, ma'am.
All right, state.
Yes, Your Honor. Violation of condition number 41. On or about the 14th day of August, 2025, in Bexar County, Texas, the defendant, Mark Anthony Perez, did then and there fail to comply with the rules and regulations of the felony drug court in violation of condition number 41.
How do you plead to that? True or not true?
True, Your Honor.
State will waive the other violation, Your Honor.
No
Any
objection, Your Honor.
objections? Did you understand by pleading true to violation of condition 41, the court could find it true, grant the motion, and sentence you up to 2 years in the prison?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 41?
Yes, Your Honor.
Court will find condition of violation number 41 true. Is there a proposed agreement?
There is, Your Honor.
Yes.
That is to revoke the defendant's probation and sentence him to 2 years TDC.
That's correct, Your Honor.
All right. Are you asking the court to follow that?
Yes, Your Honor.
Are you waiving your right to appeal?
Yes.
All right. The court will grant the motion, sentence you to 2 years in the prison, give you credit for any time served. There's an affirmative finding of family violence, and there's to be no contact with Juan Perez,
Yes, ma'am.
and there's to be no residing with minors.
Yes, ma'am.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal? With your attorney, did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. You're going to have to do better. Otherwise, you're going to end up in and out of prison, and you're still not allowed to have contact with that person that I named. You understand?
Yes, ma'am.
And that means no indirect contact. That means no calling somebody else to contact that person for you. You understand?
Yes, Your Honor.
It's as though you don't even know them. All right? All right, good luck to you.
Thank you.
Thank you,
Can I be
counsel.
excused, Your Honor?
Yes.
Thank you, Your Honor.
All right, Ernest Gonzalez. All right, yes, Miss Abrams.
Sure. So this is a compliance hearing. Do you have a copy of the supplemental report?
Yes.
Okay. So, in the supplemental report, there has been concerns in regards to Mr. Gonzalez's use of alcohol and, some failed to submit into his ignition interlock device. I spoke with Mr. Gonzalez and he has a couple of reasons that he would like to share with the court. And I do have a couple of recommendations.
All right, so what would you like to share with me?
They were asking, why there was some periods where I didn't have any tests.
Okay, so whenever you speak to me, you need to look me in the eye so I can read whether or not you're being honest with me, all right?
Okay, yes, ma'am.
So what's going on with you?
So there was an instance where I got into a vehicle collision when I was at work. I deliver mail for the postal service, and those vehicles are.
Okay, I can't hear you. I'm so sorry.
I'm sorry. Do I need to get?
Everyone, please whisper. No, you're sort of mumbling a little bit.
I'm sorry. I don't know if I know. Yeah. So anyway, there was a medical issue that I had a procedure done, so I wasn't using my vehicle for a while, and then there was an instance there where they had ripped off my catalytic converters to my vehicle, so I had to send the vehicle in. And
So that's the reasons for you not testing.
Okay, pause right here when you hear motion to revoke. That's serious. That means someone already on probation might lose their freedom, and stacking multiple new cases while out on bond. That's like poking the bear, and open court judges look at patterns, not excuses. If you were the judge, would you give another chance or call it a wrap?
The vehicle,
yeah, because there was a couple windows there that she was asking me about that I didn't have tests for.
explain the alcohol use though.
I just got careless, I don't know how else to describe it. I've been on the program for a while, and I just.
So here's my question.
Yes, ma'am.
One, did you call probation and tell them you had a accident and somebody stole your catalytic converter?
No.
Did you call them and say, I'm not going to be testing because here's the reason I'm not testing?
No, Your Honor, I didn't.
So you're on probation, and when you don't do things, what ends up happening is motions to revoke are filed. Now, Some judges, they would have looked at this and they would have just said, file a motion to revoke. And then you would have been taken into custody. Either you would have made bond or you would not have been able to make bond. And then from that, maybe you lose your job, which I don't think you want to lose your job. So the actions that you are taking are not good actions. They're not telling me that you want to successfully complete probation. So far, what you're telling me is you want to be revoked.
I hope I'm not giving you.
No, that's what I'm getting, because you're not staying in contact with probation and you're drinking alcohol. Here's the thing, whether or not you are on probation, it could be for anything. It could have absolutely nothing to do with alcohol, right? Let's say it's a theft case, has absolutely nothing to do with alcohol. You never use drugs, whatever it may be. According to the law in Texas, when you're on probation, you're not allowed to drink alcohol, period. And there's something going on with you. That's the reason why you're on ignition interlock.
That's right.
So what I'm going to tell you is, if you don't follow these rules, there may not be any more compliance hearings for you. There may just be a submission of a motion to revoke. If it's in order, I'm going to sign it and they will pick you up wherever you may be. And then we will hear your case. Do you understand?
Yes, Your Honor.
All right. What are you suggesting?
Judge, what I am suggesting is an increase in his test windows for the ignition and interlock device. Currently, I believe he's testing 3 times a day.
Mhm.
I would ask that be increased to 5 times a day.
Mm-hmm.
Weekly drug tests for 30 to 45 days. And an extension of the device for however long the court mandates.
Just give me one moment. Let me find this. And I'm sorry, you wanted weekly drug testing for how long?
30 to 45 days, Judge.
All right. And then what else are you asking for?
Judge, in reviewing his file, I did notice a TAP was completed and amended conditions were signed for him to go through the intensive outpatient treatment, monthly UAs and sober support meetings. In reviewing the file, I don't see that he has been placed in this treatment or a referral has been sent. So I would also recommend intensive outpatient treatment.
All right. Is there anything else? All right. So we're going to try this and see how it works with you. If there are issues, you need to contact probation, because you're looking at potentially, just one moment. Yaya, I'm printing something over there. If you could grab it for me, please. You're looking at potentially 2 years in the state jail facility for what you're charged with. And when you go to the state jail facility, that's day for day time. You understand?
Yes, ma'am.
In order to be successful on probation in this court, communication is key. If you do not follow through, a motion to revoke is going to be filed. Do you understand?
Yes, ma'am.
All right. Is there anything else you need from the court to be successful?
No, ma'am.
All right. Do better. Okay.
Yes, ma'am.
All right. Thank you.
Good morning.
Good morning. Is this a motion to revoke?
No, Judge, it's a motion for early termination.
All right. Could I see? Let me see what I have.
Have this. Sean.
Thank you. Thank you. All right. Who is the person on this?
Ashley Jones for the state, Your Honor.
All right. The court is calling 2024 CR 012991W State versus Kiska Stewart. Could I have parties announced?
Ashley Jones for the state. Lindsay Shopham is Stewart.
And are you Miss Stewart?
I am.
All right. We are here. Defense has filed a motion to terminate community supervision. According to this, the defendant has been placed on community supervision since December 19, 2024, and it was for a period of 18 months. State, are you in agreement?
We are not, Your Honor, just based on the offense and the amount of time.
All right.
Yes, Judge. So this was a case, it's out of your court, but it was reduced to a misdemeanor. She was placed on deferred adjudication for 18 months. So as of today, she's been on nearly 10 months. Even since the supplemental report that you're looking at was completed, she has completed her community service hours. I provided the state a copy of her donation that she made to the Texas Advocacy Project for $309. She's completed her BIP. She has now completed her community service. As you can see, there's been no concerns of her violating any no contact or no harmful or injurious contact orders. She's up to date on her fees. We're asking the court, she has a young child and she's trying to go to school, cosmetology school. And since she has been on more than half of the term, we're asking the court to consider our request for early termination.
All right. This is what I can tell you. I will strongly consider terminating you on December, because December, that will put you at a year. And what I would like is I would like the complainant to be contacted, to be notified. If you have no violations and everything is fine, December, I will terminate her.
Could I?
Sure.
So if this, not only the BIP, I've also completed VENT program through the Peace Initiative, as well as the fatherhood campaign. Being able to get off early would give me the opportunity to renew my Texas insurance license, my health and life insurance. With Medicare coming up, that is a huge opportunity, not only for me, but for my son to be able to provide for him. Open enrollment ends December. So if I could get that license.
When you say it ends December, what date does it end in December?
So it starts October 15th and I believe it ends December 1st. So there's that 2-month period, or and maybe the 31st. But there's a
all right. If somebody bring me proof that it ends at the beginning of December, because I'm not sure if it ends at the beginning of December. If y'all bring me proof of that, then I will consider early termination in November. But what I need is this is what I want you to take away from today. If there are no violations, state, you're going to have to reach out to the complainant and let them know that in November, if there are no violations, and if there's proof that early enrollment ends December 1st, then she's going to be terminated in November.
Yes, Your Honor.
If early enrollment doesn't end December 1st, if it's at the end of December 19th, if that's during the week, she's going to be terminated if there are no violations.
Yes, sir. Is that it? Okay, Judge, so will I need to file another motion or the court will terminate?
No, it will be done automatically.
Okay.
So the only thing probation will need to provide to me in November, Ms. Abrams, is that there have been no violations. You won't even need to appear. The state will have plenty of time to have contacted the complainant to let them know that your probation will be terminated.
Sorry. I will also say with this, it is my son's father, and we're also going through a custody battle right now. So with warning him, this might be ammunition to, you know.
Here's the thing. Let me just tell you. I understand. I've done CPS cases. I've done family violence cases. I understand when there are custody issues. This is what I'm telling you. If there are no violations, you're going to be terminated. The only issue with the court now is like the length of time. And I do realize that cases don't come to felony court as misdemeanors. I only handle felonies. So this tells me that this case was something else, and then it was pled down maybe to a misdemeanor. So what I'm telling you is, if there are no violations, no report from probation that there are any issues, your attorney won't have to come in and file a new motion. You won't have to come in. Probation will submit to me the early termination and I will sign it. And they're going to have to reach out to the complainant, because anytime I do early termination, whatever the termination it is, even if it's a theft case. I let the complainant know. I don't. I want the complainant to know so there won't be any issues if somebody sees someone. Because then that sometimes will result in new cases being filed, and I don't want that to happen. Okay.
Judge, can I have a date, November?
Let me look at the calendar here. Let's do, Norma, what date do you want in November? We can do the middle of November. Of course, I want it before Thanksgiving. All right, November 17th. And then if you want to stop in, Lindsay, you can stop in, but Ms. Abrams will give it to me and I will sign it if there are no violations.
Yes.
So whether it's signed or not is 100% dependent upon you. Okay. If there are no violations, and by no violations, I mean no positive UAs without prescription. If there's a no contact order, then no contact. If there's a no harm for injurious order, no harm for injurious order. No picking up any new cases. And then you won't have to come in on that day unless your attorney wants you in that day.
Yes, Judge.
All right. Is there anything else?
Yes, no, ma'am. Thank you.
And it's in my notes, so I know what I said. But my mind is a steel trap, so I'll remember it anyway.
Thank you, Judge.
All right. Thank you.
Thank you.
Yes. Thank you so much for addressing it appropriately for court. All right. So on this case, where are we on? Let me see. Discovery. Do you have the body cameras and the statements? Oh, hi.
Quick, sorry. Hey, Judge.
Yes.
So defense counsel did provide me a USB for 3 outstanding videos she can't download.
Mhm.
I'm working on getting those downloaded now, and hopefully we'll have it within the next day or so to email defense that it's ready.
Okay.
There is a few pieces that I believe we have missing from our discovery that I have requested from the detective.
Mhm.
And I also left him a message, but he hasn't got back to me yet. So I would just ask if the court would grant us one more discovery hearing to get.
All right. So
This is the moment it turns real when a defendant pleads true to a probation violation. They're basically handing the judge the authority to send them to prison right then, and their 2 years no appeal, and that affirmative finding of family violence that follows you long. After prison, especially when it comes to firearm rights, this isn't just a sentence, it's a permanent record shift.
do you know what discovery it is you think is missing?
Yes.
Yes. And what is that?
It is an interview with Mr. Pearson. I do need clarification regarding 3 video statements he had with neighbors. I do have 3 videos with him, but because the audio doesn't start until after he's made contact, I need him to tell me who those people are in his videos. So there's 3 of those. And then any potential investigation they did regarding a projectile report, if that's in existence.
Okay.
And then those 3 body worn cameras that I need to download.
Okay.
Does that sound good? Yes. Okay, perfect.
Thank you.
Thank you, Judge.
All right, Ms. Ferguson. I need, on this case for discovery, let's put this at 45 days. That will be the last discovery date. And state in 45 days, you need to be prepared to tender an offer. All right, November 10th?
That works.
November 10th?
Yes, ma'am.
All right, just have a seat. Once you sign the reset form, you're excused. You're welcome.
Thank you, Judge.
You're saying Jorge Morales?
Yeah.
All right, Jorge Morales. Hello, I know you were recently appointed, so.
I just need 30 days, Judge. He'd like me to look at the videos. So if we could get a 30-day reset.
All right, Ms. Ferguson, I need a 30-day reset on Mr. Morales, and we'll say it's for discovery. And state on Morales, an offer will be due in 30 days.
Got it.
All right, once you sign, just have a seat. Once you sign the reset form, you'll be excused, okay?
Yes, ma'am.
Thank you.
Yes, ma'am. Thank you.
You're welcome. Michelle Battles. Good morning. How's it going?
How's it going, Judge?
Oh, great. I cannot complain. Oh, counsel, you're on this side. The deputies put everybody there for security reasons. Hello, good morning.
Good morning.
Thank you for dressing appropriately for court. I really do appreciate that. All right, so where are we on discovery?
We're working on it, Judge. Let me just give you a quick background. Mr. Science was supposedly on the case, and then he wasn't on the case,
And he has represented Ms. Bettles before. So I had done a bond for him. And they could not work out an agreement. So she comes back to me with clearance from Mr. Sines that it was okay if I took over. And that does happen like a little bit over a week ago.
Okay.
So now I'm getting all the discovery, doing everything that needs to be done, videos and everything. We did get a BRAC bag. So that was the starting point, but we're just in the beginning. We've been on it for maybe 7 or 8 days.
All right. So your final discovery is going to be in 30 days. State.
Yes.
Michelle Battles, I'll need an offer, you to be prepared to tender an offer in 30 days.
Yes.
Ms. Ferguson, I need a 30-day reset for discovery. All right, so October 27th.
That's fine, Judge.
All right, so just have a seat and your attorney will bring the reset form to you. Once you sign that, you're excused. So what's going to happen on October 27th? Your attorney should have all the discovery and the state is going to tender an offer. And once they tender that offer, your next setting is going to be a plea deadline date. Understand? All right, thank you.
Thank you.
All right, and then we also have, yes?
Yes, ma'am, thank you. We were contesting the restitution. We actually have an agreement that we would like to put on the record, so we no longer have a contested hearing on that. It should be much shorter.
All right. And so what is the agreed?
It'll be $7,300 agreed to Zua Zua.
Good morning, Judge.
Good morning, how's it going?
Good, and you, Judge?
Oh, I'm doing great. All right, the court is calling 2024 CR 6325 State versus Luis Alec Martinez. Can I have parties announced for the record?
Lauren Espinoza for the state.
Joseph Davidson for Luis Alec Martinez.
And are you Luis Alec Martinez? We have an interpreter. If you could raise your right hand. Do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you can lower your hand, state your name for the record.
Cesar Chavez, license number 2203.
All right. So we are here for sentencing, and there was also an issue with regards to restitution. The defendant agreed that he owed a restitution amount to Juvenile Flores in the amount of $17,240.80. The restitution amount to Jesus Zua Zua was previously not agreed to. It's the court's understanding that agreement has been reached in the amount that's owed for restitution to Jesus Zua Zua. Is that correct?
Yes, Your Honor.
State, is that correct?
Yes, Your Honor.
And what is that amount?
That amount is going to be $7,300.
All right. And the person before me, is that Jesus Zua Zua?
That is Mr. Jesus Swaswa.
Swaswa.
Yes, ma'am.
See, I'm saying Zua Zua because
I said Zua Zua.
you're supposed to help me. I'm trying to learn. All right. Could you raise your right hand for me, please, sir? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I swear.
All right, you can lower your hand if you'll state your name for the record.
Jesus Guadalupe Suazua Maltos. Jesus Guadalupe Suazua Maltos.
All right. And I'm sorry, the last name?
Suazua. Jesus Suazua.
But he had said something.
Maltos. Maltos.
Maltos. All right. So both parties said that they're in agreement with a restitution amount of $7,300. Do you agree that that is the restitution amount that is owed to you?
See. Yes.
All right. Any other questions?
No questions.
Nothing from the state.
All right. Thank you. You may be excused. And I don't know if they'll continue to need you for the sentencing,
Not for my clients.
but I mean for Mr.
Suazua Maltos. Do you
Yeah.
want him to hear the sentence?
Yeah, probably.
Okay, then I'll stay.
Would you like that state? Okay.
Okay.
All
Do you
right.
want me to stay here?
You can state
Actually,
this.
step back there.
All right. Thank you.
This is one of those rules people underestimate. It's just alcohol not on probation in Texas probation terms are strict even if your original case had nothing to do with drinking. The judge is spelling it out. Communication and compliance are everything, Missa. Test, don't report, don't explain, that's how revocations happen. So here's the question, is probation meant to rehabilitate, or is it a test most people are set up to fail? Now this is strategic judging high bonds, GPS curfew constant check, and it's controlled freedom, not jail, but not liberty either. Courts do this when they want leverage without overcrowding a jail, the message you're out, but barely do you think this kind of tight supervision actually prevents new crimes, or does it just delay the inevitable?